Okay. Everyone received the take-home question for the midterm?
Yes.
Yes.
Okay, no questions, right?
I
Yes.
received it. I didn't receive it. This Colette.
How come? Hold on. Okay, Colette. Okay, give me your email. Colette. What's your email?
Okay, sorry, my mic was off. SIGMA,
Mm-hmm.
peach as in the fruit. 89 at Yahoo.
You said peach as in the fruit?
Yes, ma'am.
The word peach?
Yes, ma'am.
Okay, Sigma peach.
Yes, ma'am.
Okay, all right. I thought I sent that to you, you know, I'll double check. Okay, everybody else received it, right? All right, hold on. I gotta look in my sent box. I could send it to you now. Sent. Okay. And you got my email that we're gonna do chapter 7 instead of 6. Because I don't want you to get confused for the exam. Correct?
Okay, nope.
Hi. Hello?
Yeah. Yes, I'm here.
So you saying we studying chapter 6 for the midterm?
No, that's why I'm not doing it. So you don't get confused.
What are we doing? What are we studying?
Chapter 7.
No, we're doing chapter 7 tonight, which is something that you know.
So what would be on the midterm? Just chapter 7?
I can tell you, no, I can tell you what on the midterm
Okay.
in 2 seconds. Let me just forward this to Colette.
Okay.
So she's not in the dark. Because I'm sure I sent this to Sigma Peach 89 at Yahoo.
Yes,
Yes,
ma'am.
Colette.
And that's it going in the junk.
Okay,
Yeah,
check again.
she love
I
to
just sent it
search.
again. Check.
Okay, let me check. Okay, I get it.
You get it? Okay. 'Cause
Yes,
I sent
ma'am.
it earlier, just in case I missed, but I thought I did. Let me see if I sent you the right thing. Let me see, Colette. No, I sent you the wrong thing, Colette. Delete that.
Okay.
Let me see. Where is it? Let me see, few more. Okay, I have it now. I found it. I found it. Forward. Sigma. Peach. Okay, that's it there.
Okay, let me
I
refresh.
don't know, on my phone, it still says draft. I don't understand. And I sent this to you all already.
Okay.
Okay, so the other one I sent you, delete that one, and then you could go from, use that one what I just sent you.
Yes, ma'am.
Okay, so, all right. So now the midterm exam is on Wednesday. and it covers chapters 2, 3, 4, and 5. That's it.
Okay. Okay, so I was doing something right.
Right. So the chapter that's on contract, you will have questions on contract, but be mindful that the scenario question is the one that I sent you as take home. So you don't have to memorize no case law to do no scenario for the exam, not for contract. You only have to do it for banking law. Now the banking law midterm, the midterm has only 5 questions. Only 5. One of them has 2, 4, 6, 8, 10, 12, 4. One question has 15 questions. Those 15 questions, when you answer those, you only need to write me 2 sentences, 3 the most. So do not spend all day answering those questions and writing long paragraphs. They're very short. So for example, I may ask you, what are the essential elements of a contract? What's the answer for that?
An offer.
Offer and acceptance, consideration.
2 more.
Offer, acceptance, consideration.
Capacity
And
to create a legal
legal
relation.
relations. That's it.
Right.
So you don't even need a sentence. Another two.
I didn't hear that piece just now.
What are the elements of a contract?
Oh, that's what you asked. Okay.
Yeah. So you don't even have to write a sentence. That's just a bullet point. Okay.
Okay.
Another quick question is, what are the 3 rules of statutory interpretation? What is that? Don't look in your book. If you don't know, you can look it up when you study. You could remember? No? You remember? The literal
No.
rule, the mischief rule, and the justum generis rule. You know the difference between a gratuitous bailee versus a bailee for reward? Remember, I told you that you have to know the duties and the rights of both the customer and the client. So these little short questions asking you on one of those things on both sides. So that's just the list. You should know the rule in Clayton's case. Remember when we went to the banker customer chapter, I said that you have to know, we actually demonstrated it in class when a person becomes a customer. You could recall? When does a person
Yes.
become a customer?
Once the
When they open
document
up an
is,
account?
they sign the
What does that
document.
mean?
Pardon?
What does that mean when they open? If you gave me that answer, you'll get 0.
Oh.
So that means that once they sign the documents, both parties sign the documents, and the funds are received and placed on the account.
Exactly.
Where the heck
Okay,
is my glasses?
so you can't say when they open, when the customer opened the account. It is a process. And that
Okay.
process demonstrates the elements of a contract: offer, acceptance, consideration, intention to create legal relations, and capacity. Because remember, when if a child has to open an account, who must be there? A parent or a guardian, because they don't have the capacity to enter into a contract. What else? What else you should know? You remember when we were studying, when we studied and discussed the court hierarchy? And we said that a court has to follow precedent. You should know the difference between a binding precedent and a persuasive precedent. You could recall that? What's a binding precedent? This exam is in 2 days, you know.
You said that the difference between a binding and a what?
A binding and a persuasive precedent. Can remember?
A binding and I like face-to-face class.
Binding is what? Come on, you all knew this. What's a binding precedent and what's a persuasive precedent?
A binding precedent is like when there was a case prior and they're using that as a benchmark to adjudicate one that's present.
Okay, so a binding precedent means that it was a case that was decided in a court above the court that you are in. Remember when I told you that? Based on the hierarchy of the courts?
Right.
So if you are in the magistrate court, and if your facts are the same as the case that was decided upon in the Supreme Court or the appeals court or the Privy Council court, or the Privy Council, you are bound to follow that. What's the persuasive precedent? What's persuasive?
Wouldn't that be on the same?
Go ahead, explain it to me.
Okay, so they're on the same, like there was a case prior to in the same court jurisdiction that had similar issues.
No, that's when you're going to distinguish.
Oh, okay.
Yeah, that's when you would distinguish. Persuasive means when there is, again, like you were saying, a similar facts, but it's from another Commonwealth jurisdiction. It becomes persuasive. Remember, we are a common law country, and so we can use cases that come from other common law jurisdictions. You can use cases from Canada, United States, Malaysia, India. They're all a part of the Commonwealth. You should know the rule in Clayton's case. When can a minor be bound in a contract?
At 18, eh? You ain't no more minor.
Yeah, but I explained to you when a minor can also be bound before the age of 18. What did I say?
Is that when they sign on to an account with an adult?
No. That's when they make purchases for necessaries, remember?
Oh, yeah, you said that, yeah.
Yes, you did, yes.
Okay.
Say that again, please.
When someone under the age of 18 goes to a shop and they can actually establish an account if they're purchasing necessaries. So it means like their underclothes, maybe a coat for the winter, maybe some boots, maybe raincoat, whatever they need, or even if they're going to buy groceries, they will be bound as long as it's necessary for them to live off.
Okay.
Okay? So that's necessaries.
How common is that? That's not very common, is it?
How common is it?
Yeah.
Affluent persons normally do it. Yeah, the rich people.
Say the rich people,
Mhm.
because they give their children credit cards.
Yes. And their children can go and establish an account just based on their name.
Yeah. Better
And
teacher.
then, yeah, they're legally bound.
So when you say legally bound, if the department store were to sue, they're suing the child, the minor?
Yes. Because he purchased what we call necessaries. Okay, let's just say he went in the store and he purchased a golf cart. He will not be bound because that is not a necessary.
Right.
But he went in the store and he purchased some socks, some shoes for school, or tennis shoes, or maybe I don't know, some softball outfit. He plays softball as a part of the school curriculum. He will be responsible for that bill.
Is there a minimum age in this case?
No. It's anyone under the age of 18.
Okay.
All right, what else should you know? How do you discharge a contract? We've talked about it a lot.
In writing?
Okay, so if you're in an auction and you make a bid, but before the gavel hits and you can rescind it, that's an offer and acceptance.
What do you mean? That's an offer and acceptance.
That's a contract, yeah, that's offer and acceptance, so that's a contract.
No,
verbal
don't use
no.
that word contract. No, don't use that word
No,
contract.
okay.
In order to have a contract, what you need, all of the
All parties
essential elements.
agreement. Yeah,
Yes.
and that
You need
doesn't have it.
offer and acceptance is equal to an agreement. So you need, what you would have is an agreement. You won't have a contract.
Right.
An
that's
agreement
the-
means that,
sorry.
right. Agreement means, and if you have a contract, it means you have offer, acceptance, consideration, you have the intention to create legal relations, and you have the capacity to enter into that contract.
Charging it is when everything is done. When you say, well, you offer me a car, you advertise the car, I come look at the car, I say I want it, we write up a contract, everybody's name is on it, we sign it, and we exchange funds. And you say, okay, go with God, and I'm done. So
That's a contract.
Discharging it means that it's complete, it's done, no one's coming back looking for anything else. It's complete.
There could always be a dispute whereby one of the parties could say, I didn't really mean to enter into an agreement. That's the part where they call about intention to create legal relations. That's what that means. What that means is that if you and I if I'm purchasing an item from you, you have to be sure, and I have to be sure that that is exactly what we are doing. That is our intention. You actually intend to sell it to me, and I actually intend to buy it from you.
Right.
That's what intention means. Remember, in class, I said, whenever you're dealing with law, the first thing you always have to remember is law deals with what's in the mind of the person at the time the transaction was taking place. That's always key. What was in the mind? What else? So how do you discharge a contract? How do you bring a contract to an end? I think I gave you 4 or 5 examples in your notes. Remember, one can be frustration. What's another one?
By breaching the contract, by breaching it.
A breach, yes.
By carrying out the obligation, by just for performing whatever's in the contract.
Performing what's agreed, yes. So you have to know that. Then our next question could be on, remember we did in chapter 2, we spoke about the whole process of how a bill becomes an act. Remember? Vaguely, eh?
Very vaguely.
Okay, so remember now, this is how it works. In a government ministry, and most of them, they have a legal person. That legal person would either draft some amendments to the existing law or draft a brand new piece of legislation. When that legal counsel in the government ministry has drafted it, they send it out to their licensees for their comments, advising them that this is what we propose and this is how we intend to deal with it. When they get the comments back, they make whatever changes there are to it, and then they send it to the AG's office. The AG then would go and do a like a research and look and see what other countries have done to address the same problem. Even though the legal counsel in the ministry would have done the same thing, the AG's office does their own research. So the AG's office looks at it, makes some changes to it, sends it back to the government ministry. The government ministry, if the changes are substantial, will send it back to the licensees and see if they have any further comments. If there are no further comments, it goes back to the AG's office again, and then the AG's office will give it to the minister who's responsible for that ministry to table it at the next sitting of Parliament. So you notice when an MP gets up, he says that he's reading the long title of a bill, and then he tells you in summary why this bill is actually being tabled. That is the beginning of the process of how a bill becomes an act. And so you have a first reading, a second reading, a third reading, and then you have where they put it to vote. And after that, it goes to the Senate. The Senate goes through the same process for a second, third reading. That if they agree, then it would go to the Governor General for assent. So you have to know the steps that the bill goes through once it is presented by the minister in Parliament. That's understood, right?
Yes.
Okay. Let me see what else you need to know. I hear much from Doris tonight.
What do you mean you hear much from me?
Oh, hearing you now.
I was answering.
I know you was answering, but I know you always have plenty questions.
Yes, ma'am.
All
Yes.
right, let me see what else you need to know. You should know what consideration means.
Yeah.
So make sure you focus on that. I remember when we started the banker customer relationship. Remember, the first thing you learned is, how do you define the term banker? How do you define that?
Question, as an officer who is, I guess, charged with the duties of the business of banking, which involves entering into a contract with a customer whereby, well,
Say that again. Say it again from the beginning.
there's like an officer who is charged with the duties of executing a contract with a customer. That contract is whereby a customer exchanges money or deposits money into a particular account, and the bank is like the banker, then I guess you would say becomes the, I don't want to say trustee.
The representative of the institution?
Okay, now remember, this is banking law.
Right?
So which legislation you go to define the definition of banker?
The banks and trust, the bank.
Companies Regulations Act,
Oh.
right? And remember when we did it actually give a definition of banker?
Yeah, it did.
It did?
Yeah.
What it said?
Bank and trust.
Did it tell you who was a banker? Or did it
No.
give you the definition of banking business?
I gave you a definition of banking business. That's
Okay,
it.
right. So if I ask you to define the term banker, what would your answer be?
That's the business of accepting deposits of money.
Exactly. So your answer would be the legislation, the BTCRA does not define banker, however, it defines the business of banking. It's not defined in the act. So you would have given me the definition of what is a banker by dictionary. But if you were to do banking law, the law itself, you start off by saying that the legislation that governs banking, the Banks and Trust Companies Regulations Act, does not define banker, but defines banking business.
There's a section here that says that talks about investing them for the account at the risk of the person accepting them and without limiting the generality of the foregoing includes the provision of money transmission services, and banker shall be construed accordingly.
Yes. That's the section.
Okay.
But what it actually defines is banking business. So
Right.
banking business includes all of the activities that a bank does, and money transmission business also falls under the definition of banking business. And they said that a banker should be construed. So even a person who works in money transmission business is a banker.
Right.
Ms. Archer,
Yes.
that someone has there's a lot of feedback coming from somewhere.
Yeah, not me. I have everything off. It's gone. Thank you.
So why doesn't it define banker?
Why doesn't it?
Yeah.
Because really it's the activities that a bank carries on. It changes over time.
Okay,
So really what the legislation is regulating is what you do,
right.
not the name that you are called. All right, so those are the little small little questions for you to answer. Do not take all day and waste time writing long paragraphs. I've already warned you, don't waste your time. Answer. So then you have some scenario questions. You have 4 of them to do. One of them has 3 parts. The 3 part, that question is only worth 10 points. So do not spend all day answering those 3 parts because it's only worth 10 points. You should know what is a banker's lien. What is a banker's lien?
What is a banker's lane?
Lien.
Oh,
What is that?
a lien is when you use something like collateral almost.
Yes.
When you put a lien against a property, you're using that property in exchange for, or in the event that the person defaults on this particular agreement, then you would use the property to liquidate.
Yes. Okay. You should know what rule was established in the case of Foley versus Hill. All right, let's go.
I don't know.
This exam in 2 days, you know.
Yeah, because exactly, we have 2 whole days.
Oh, stay right there. What is the case of Foley versus Hill? Did you read it? It's online. What is Foley versus Hill? I should not have silence. Foley versus Hill. That's on the first page of the banker customer relationship. Foley versus Hill established that what? When you establish a banker customer relationship, what happens? The funds that the customer has deposited in the account is a what? Credit. Remember?
Debtor and creditor.
Ah, there you go. And it's the reverse if you have a loan, correct? Yes, it's in reverse because now
Yes.
you owe the bank.
Yes.
Okay. And that was established in the case of Foley versus Hill. You cannot say you completed banking law if you do not know some of the key cases. You have to know Foley versus Hill. That established that once a banker-customer relationship has been established, that customer is a creditor of the bank. And by them being a creditor of the bank, then that's what? That falls in line with what? The duty of the bank to pay on demand. A customer's request for their funds from the bank or from the branch from which they established their account. That's a right in law. The next case you need to know is UDT versus Kirkwood. What is that?
UDT?
Yes. UDT versus Kirkwood. Why have so much silence?
I know.
That's right. That's on the very first page of that chapter. Come on. All right, I'm reading. Who's volunteering? Walton, was that you?
Wasn't me, but it talks about a banking business.
Okay.
Paying, it has to do with repayment of a loan coming under question because it was made with, I think the loan was contracted with a company that wasn't under the Bankers Act or something like that, or Money Lenders Act. Not
So
very-
what the essence of the case of UDT versus Kirkwood is the court had to determine whether or not the activities of the company was actually banking business.
Right.
And at that point in time, the law established that based upon the nature of the activities that were being carried out, that yes, it was a bank. And it defined what is a bank at that point in time. So if I come and I go to a present day, you know, when they list these companies on the central bank website, and they say that these people have violated the act, which means that that company was doing a business that is defined as banking business without a license. That's how you determine who is a bank and who isn't a bank. It's based upon the nature of what they do in law.
Mhm. Did you say the bank, whether a bank is a business based on what they do? What about whether or not they're licensed? But it only could be
If
licensed.
you okay, if you're doing business, let's say you open a company and you are taking deposits, right? And then you're giving loans, but you're not licensed.
Right.
The central bank has the authority to say you are conducting banking business without a license.
Right.
They have the authority to close you down
Right.
and also prosecute you in court.
Okay.
So that's what I'm saying. That case itself, UDT versus Kirkwood, that determined what is banking business at that point in time. So let's just say 10 years from now, everything is changing. We had this pandemic. Let's say someone comes up with some way of doing banking, different from what we know. Something happens. And then they say, oh, the regulator should have been aware. Then the regulator will say, but according to banking business as defined in the act, what they were doing was not banking business. So then they would send them to court. And then they have to determine whether or not, based upon the nature of what they were doing, whether or not it is actually banking business. And that'll be not just what was being done in the Bahamas, but looking at it worldwide. That might be a trend whereby the way in which we do banking now probably change over time, but we didn't amend the legislation to reflect the new changes in what is termed banking business. Banking gets complicated, eh?
Yeah.
Okay,
Yes, it does.
so that's a 3-point question. That's one question with 3 questions, and it's only worth 10 points. Do not take all day to do it. Focus on the other questions that are worth 15 points each. They are scenario questions. You remember when we finish the chapter on contract law, and I said to you, or we discussed in class, I think Waltine and Doris was on top of it. And then everybody echoed in more to the end when I say, let's look at the relevance of contracts to banking. And remember, we went through each one of the elements side by side, comparing a contract versus a banking contract.
Yes.
Okay, you will see that again. Did everybody get a copy of the handout?
No.
Who's no?
You emailed it or?
Then you should have gotten it from the office. We sent it out last week, Wednesday, and I told them the office to send it to you all.
Oh dear.
What is it?
You didn't get it?
The handout? No.
Oh, they didn't email it.
Oh, they didn't email it. Oh, Lord. But I
I
thought he
did.
said,
The
I'll
one
check.
we got in class?
yes.
Yeah, some of us got it. I mean, I guess the ones who wasn't there didn't get it.
No, but I remember when he bought them and I said, make sure email it to those online.
Oh,
Okay.
I did.
Well,
I
I'll check.
did. Can someone send it to Doris and Walton? You have it handy?
Yes. Let me see if I can scan it.
Yeah. So there's a question on that. There's a question on bailment.
Oh, and what is that, sorry?
Hmm?
There's a
Repeat
question
that.
on,
Bailment. You know what bailment is?
bailment?
Yes, bailment. B-A-I-L-M-E-N-T.
Bailment, oh, wow.
All right, someone explain what's bailment. Come on.
Being able to get bail?
No, this is not court, criminal court. What's bailment?
I don't know. Hold
Uh,
on.
Come on. Come on, come on, let's go. What's bailment?
delivering.
You all know this. Come on.
It's like when you're giving goods for a reason or purpose or something like that.
This is when you go into a bank
Mhm.
and you
Deposit.
enter a contract to put items into safekeeping.
Yeah, safety deposit.
Right.
No, like jewelry or whatever you put in a safety deposit box.
Right,
Right. That's what bailment is.
okay.
Bailment is a legal relation, an actual legal contract with the bank. And by entering into bailment, the bank has certain duties and responsibilities.
Mhm.
So there's a scenario question and you have to provide some advice.
Okay.
It was interesting that when I was reading up on the dormant accounts that it said that the central bank should be getting those as well, but that doesn't happen.
Oh, that will be happening very soon. They just haven't gotten there yet.
Oh,
The laws are already in effect, so most likely what they're trying to do is put the mechanism in place in order to take it.
Okay, so when they receive the funds off of these dormant accounts, the bank has to retain the documents and the signature cards and stuff. Do they also send a copy of these along with the funds to central bank?
No, as far as I'm aware,
Okay, just asking.
no, it's just the funds go. I think the bank themselves have the responsibility. The signature cards and stuff wouldn't go.
Okay.
I can't recall if they send the name of the client. I think they do send the name of the client.
They do send the names actually.
Yeah, but not
So
the
they-
KYC.
Okay,
And that
so
is happening now. That is happening now.
They are
so if-
sending it, right?
Yes, sir.
Mhm.
So now, after the bank has held it for 7 years in dormancy, when it goes to central bank, how long is it held at central bank before the government or central bank decide to do work?
I can't remember because I don't have it in front of me, but they have different time periods before the government actually takes it and you can't get it back.
it's like 25 years.
Something like, yeah, I don't have it in front of me, but yeah, they have a time limit. So what that means is that the millions of dollars that they have now, that they've been holding from the inception of when the dormant account came into being, those funds are going to be taken by the government.
So that 25 years starts with central bank on day one, they receiving the money. It's not inclusive of the bank, the 7 years with the bank.
No, you see, the whole purpose of amending that section of the act was that central bank is holding a lot of money that persons have not come to claim. So if they did not amend the law, those funds would still sit at the central bank waiting endlessly for someone to come and claim it. What the government is doing is saying, okay, we need to put a time limit on this.
Right.
Because the funds are sitting there, the people are not coming back for it. Either their relatives don't know it exists or they don't want to come and get it. So the government is going to take it.
Right.
And it's as simple as that. And don't forget that as domestic banks and offshore banks. And the next question that you have, oh,
Okay.
hey,
That's a wicked
now,
grin.
yeah, this is a wicked grin because I gave you all 2 Bahamian cases, 2. One, we're going to discuss after we have finished next week, chapter 6. That's the one for 79 pages that you all are dying about. You would have had almost 3 weeks to read it, so you could die and keep dying. But last week, we spent some time going over a particular case in class. Did we not? What was the name of the case? Why keep getting silence?
Maurice and something. It was recent.
Yes. Who's the something?
Scotiabank.
Okay. All right. So if you didn't read it yet, Maurice Clinton versus Scotiabank.
Scotiabank, yeah.
Okay.
And remember, everybody got excited when they say, oh, the case of Jameson Swiss in this. Yes, it is. So if you didn't read it, because I told you to read it, you will see it again on the exam.
Wait now, hold on. This
exam is
It's actually funny too, boys.
Miss Asher, the case of Maurice Clinton versus Scotiabank?
Yes.
All right, we have that case, so I could find that.
Yes.
Okay.
Remember, I sent you all if you don't have the link, I gave it out in class.
Oh, God.
And I asked them to send it to you too.
Mm.
Oh Lord, this can be long.
No, it ain't gonna be long. Because it's a Bahamian case, you're gonna love it. Somebody has it. Who's there who can scan it?
So what exactly we gonna do with this case?
I have a question.
Oh, okay.
I have a
Oh,
question.
boy.
And that's going to be your reference point.
What a time.
It's not a time. Hold on. All of a sudden now, it could be a time. How is that?
It sounds like a lot of information that we need was not channeled to us correctly. And I think that's why a WhatsApp group kind of helps, because it kind of helps you to kind of keep on the same page. So we were little reminders and things, because I lost. When you talk about these pages you're supposed to be getting, I wasn't in the class last week, so I didn't get anything.
Okay.
Mm-hmm.
All right. So, okay, so you weren't in the class last week because you just joined, right?
No, I was on the Zoom. I could not hear anything.
Oh, yeah. I forget you were on the road, right?
That was me, Miss Archer, Denise Thompson, that just joined.
Okay, yeah. Denise just joined. Denise, you ready for the exam?
That was a joke, no?
Denise and I ready, but
What's wrong with George?
Me too. And I just got the Zoom link today after asking for it from I don't know how long.
Okay, so let's see. No, let's hold on now. We have people who have been in the class in the beginning. Now, I know Denise just started. Denise, if you want to.
remember we had a whole holiday in there too, you know.
Yeah, but I mean, Denise, Waltine, and
And Doris.
what Doris? Doris, don't try it.
Oh, I missed last week's class, man. I got stressed.
Tia.
And I know Tia. So let me say, what if Waltine, Tia, Denise, and Doris? You have to take it on a different day, but you can't take it on my school days.
That's fine with me.
The following week.
Awesome.
Yeah, that's fine.
Okay,
Yeah,
so
that's good.
you four.
Miss Archer,
Who's this again?
this is Bernice. This Bernice. This is
What
Bernice.
happened?
Now
Bernice,
remember, I had sent you an email to let you know that I'm off the island, so I would need to take the test with them as well.
Oh Lord.
You
Okay.
remember though? You remember?
Yes,
I
yes,
think
yes.
everybody should just take the test once.
Yeah, man, Miss
Ah,
Archer.
Yeah, because
don't
we
try it.
next week. Might as well
Don't
make that
try
next
it.
week.
So,
So I guess you can let us know which day next week we can do it.
no, Miss Dean, I have to tell you,
Okay.
because you have to go into the class. So Colette will take it tomorrow. Right, Colette?
Tomorrow's Tuesday.
Tomorrow?
Yes,
I mean,
ma'am.
Wednesday.
Whatever day, yeah.
Okay, Wednesday. McQuell, you'll take it on Wednesday?
I don't think I have a choice, right?
No, of course not. You could do this, man. Don't mind all of them making noise, you know. Next time they take it next week, they can still be dying.
Man, I so finished. That's just trouble.
Yeah, she's right about that though.
Old too, boy. I'm just telling you. So you two can take it tomorrow. I mean, on Wednesday, and then you all can take it for next week, and you could ask Miss Dean which day you can come in to take it.
Awesome.
Okay.
Sounds good.
So
Does Ms. Dean have the note for us to collect?
which note?
You talked about some leaflet, something you said you sent 3 pages.
You mean the case?
Yes.
The guy who was in the office had scanned. He's supposed to have scanned it to you. That's why I say if someone has it, they could just send it to you. Or that would be good. But didn't I send you all an email earlier with the cases in it
No.
as a link?
Yeah, you sent it to.
Yeah, you sent something this way.
Yeah.
So Miss Archer, this is Denise again. Can I, well, because you don't have my email address.
No, give me your email.
LOV, you ready?
Yeah. Go ahead.
LOVELY, lovely.
Uh-huh.
RINGY, ringy.
RIN.
GY
Uh-huh.
at hotmail.com.
Okay. Lovely ringy.
Yes, ma'am.
Oh my Lord. Can never remember that. Okay, so Denise, you need what all you need?
Everything. Everything.
Good Lord, that's plenty things.
Exactly.
Well, she need everything. Well,
Waltine, you do not need no everything. You do not. Don't try it. Vernique, what do you need?
I have everything. I just.
You have everything.
Yeah, I have everything.
You think you could scan, what could you scan to Denise?
I can scan her some things, but it'll be PCs because I have to do it from my phone.
Yeah, that's all right. So send her the one sheet with the contract versus banking, the relevance. Remember the one sheet?
Yes.
Okay, send her that. The Maurice case, I will send her the link.
Okay.
I'll send her that. What else we had? Denise, you know how to look up Foley versus Hill on the phone? Go on the internet, look up Foley versus Hill.
Will it come up if I do that?
Yeah.
I could do that. I mean,
Yeah. You can look up Foley versus Hill. You can look up UDT versus Kirkwood. Doris, what you missing? Nothing, eh?
I still didn't missing this contract versus banking.
You
I
need
don't
that
think
too?
Yeah, and then the link to the case for Maurice.
Okay.
Benson. And the handout you were referring to, I don't know.
Okay, okay, so if all of you can get that relevance
I
of
mean, if we're gonna
contract,
do if you're gonna do a WhatsApp group, when I scan it, I could just put the document in the WhatsApp group
That
for
makes
Okay.
sense.
contract
That makes
versus
sense.
banking.
yeah, I think that would be good. And I'll just say,
Also, I see there's another one. You have Maurice Clinton versus Scotiabank, and then
No,
there's a
ma'am.
next. No, I mean it's two that we have. So I'm just trying to figure out what.
Makushla will be for the final exam.
Oh, okay.
Oh, Jesus.
What happened, Doris?
That gonna be for the final exam, 79 pages.
100 page one.
Hold on. Now, when we did our contract case last week, Waltine and Doris said they couldn't hear good, right? So
I was
those
on
who were
the
in
call.
class,
Yeah.
huh?
Yeah, I was on the call.
Yeah, but what we learned from our contract case is the same way a contract case is answered, is the same way a banking law case is answered. So when you read Makushla or you read Maurice, the first thing the judge does is he gives you the facts. And sometimes the facts is long because some judges, what they do is they copy the summons that's prepared by both sides. You know, the affidavit where a person would say, I entered in a contract with the bank on such and such a day. I did this on such and such a day. I did that on such and such a day. Some judges copy those and put them within the actual judgment.
Mhm.
And then what the judge does after each affidavit that's prepared, he will ask the person, the plaintiff, some questions. And then he'll copy the next affidavit of the next person. And then he'll ask them some questions. So that's why you'll see some of the judgments are longer than others. So first is the facts. Then he's gonna come down and maybe 2 or 3 paragraphs and he could tell you what is the question that he's seeking to answer. And remember what I said when it comes to banking law. When it comes to the issue is either what? Either the bank breached one of his duties or the bank did not get the right that it was looking for, or the client breached one of his duties, or the client is saying one of his rights was not met by the bank. That's the issue. At the end of it, it could be that the contract was discharged. And it could be discharged by different reasons, which we discussed already tonight. Then what is the judge going to do? He's going to give you the law. And in the law, he's going to state the cases that you see in your notebook. He's going to talk about Johansson versus Swiss. If he's talking about bank statements and querying, he's going to mention the case of tying. And then he's going to come to his conclusion and tell you who's wrong. So there's no need to scream about 79 pages. All you really need to know is what are the facts? What was the question? And then look at the law he presented and the conclusion he came to. And we will discuss that in class. It's not as long as you think it is. Didn't we have fun reading Maurice last class? Yes or no?
Yes.
Yeah.
Okay.
Yes, ma'am. It
And
actually
you
was.
find out, right, and you realize that those same cases you see in that book is the same cases that the judge used. The only way a judge would not, take the duty of confidentiality. Remember I said that was established in the case of Turnier. And it had 4 exceptions. If you were to go before the court now and say that the bank breaches duty, the judge may mention the common law case, but he doesn't have to. because the Bahamas has enshrined that case in the Banks and Trust Companies Regulations Act. So it wouldn't go to the common law cases because there's actually law in the Bahamas. Okay? Y'all getting this now, right? I ain't hearing nothing. What home means?
No, could you repeat that, please? Could you repeat that, please?
Okay, so what I was saying was this. If a bank breaches duty of confidentiality, we know that according to common law, the case is Ternier versus National Provincial. And we know in that case, the court established that there are 4 exceptions to confidentiality. Right? I'm saying if that matter comes before the court, our local court, the judge will maybe mention the common law case of Ternier.
Okay.
But he would base his decision on the section in the BTCRA. Because that duty of confidentiality is enshrined in our law.
Okay.
So he will go to the law to answer that.
Okay.
Like a binding as opposed to persuasive?
No, not to do with that. This is the law.
Oh.
In the act itself, there is a section on confidentiality.
Okay.
And that is what he will use. Now, in terms of looking at cases that may be close to the situation that's before him, he will have to look at whether decision was made in the Supreme Court or the Court of Appeals or the Privy Council. Those would be binding on him. And if he can't find any cases that have the same issues as the one that that's in front of him, then he may go to another Commonwealth jurisdiction. Canada, Malaysia, India, any one of those Commonwealth countries, which will become persuasive. Okay?
I have a question, please.
Go ahead.
So when the judge stating the ruling, he has to cite a case, not necessarily a.
When he states the ruling, he would have already stated the case in the section on the law.
Okay, so what he's using, okay.
Yeah, that's where he's gonna come down and tell you. He'll either tell you, I cannot use the case of so and so because it is persuasive, and then he'll tell you, or he may say, I am bound to follow the case ruled by the Court of Appeals. He'll give the name of the case, but then he may say, however, I have to distinguish it from the present case before me because the facts are not the same. That's why I want you to read it. So if you have any questions, you could ask and you'll have a better understanding because there are a lot of banking law cases that go before the court. A lot of them. And then like the comment was made on Wednesday, a lot of them relate to Scotiabank.
Yeah, Scotiabank always.
Yeah, but a lot of the mortgages are not Scotiabank though.
Who are they?
Different banks. Yes, there are some mortgages.
You have
I just
some
didn't want.
mortgages. They have some mortgages where there's no security and they sell property that isn't the person owned. So people are paying for property that they're paying for something that they don't own. So how do you fix that?
It depends on how the contract was entered into.
So Joseph sells me a piece of property, but it's not his own. The lawyer does his search, brings it to the bank lawyers do theirs. And then it turns out that a third party comes and say, no, this is my property. And they proceed to present their property and it was registered. How does that work?
So start from the very beginning. No, start from the beginning.
Okay.
So you sold me a piece of property, correct?
Yes. Uh-huh.
Okay, you sold me a piece of property. Now, we entered into a contract. Was that contract legal?
No, from the
Okay.
beginning, no.
Okay, so that isn't legal. So now let's go to the next step now. You're saying that illegal transaction that we took out went to the bank, a lawyer would have done their title search,
Yes,
and they came back and said that the property that was sold to you illegally was a good title.
yes.
Then now that there comes a matter now to sue the attorneys for negligence.
But they are also, so you already got the mortgage now on this, you've been
Hold on,
paying
we ain't
for
get to
this.
the mortgage yet. We ain't get to the
Okay.
mortgage yet.
Okay,
So now, based upon what the lawyers wrote, the bank then relied upon that and entered into a mortgage agreement with you. Correct?
correct.
So now the bank also has an action against the attorneys.
Jesus.
Now, your
Okay.
problem comes in now is that now you have been paying the bank for something which the seller sold you that doesn't exist. But the bank relied upon the lawyer saying that they had good title in order to extend the mortgage.
Correct.
So now the bank has to go behind the attorney.
So do you still have to pay the mortgage?
You're gonna have to pay the mortgage because you entered into a contract. You're
So
gonna
now
have to, you're gonna have to bring a lawsuit against the person, one, who you bought the property from, and two, from the bank who did the title. In most instances, the person who you bought the property from can no longer be found.
Okay.
And neither
Now
can
you
the lawyer
understand?
be, neither can
You
the
see?
lawyer be found.
And sometimes the lawyer cannot be found, and in some instances, the lawyer is broke. And sometimes the lawyer is broke.
So
Who's
the
that
so the buyer is the one who is out, because the bank ain't gonna
Yes.
never be out.
Not saying the bank can never be out, because the bank now has to sue the lawyer for negligence.
Yeah, but they suing it, but in the interim, the purchaser still is paying the bank. The bank could sue them.
Yes, because the
purchaser
bank,
could sue
don't
them.
forget now, don't forget, the bank has already expended the money.
Mhm.
You have taken that money. That consideration, that is gone. You have a contract to pay back those monies. And the problem for the bank now, which is a risk, is that the underlying security does not exist.
Mhm.
Right.
But
So
you have taken that money.
okay, so now the seller has taken the money, but the buyer, the person who is now paying the mortgage back, they can't stop paying. So in essence, they pay straight through and they pay even interest upon something that they even don't own or have. So whether the bank sues that person, the lawyer, whatever, they still getting their money.
Hopefully.
With interest.
Twice, actually, because they suing the lawyer and they suing the person still paying back.
Right.
Mhm.
So
But
question.
don't forget now, when they sue the lawyer, they only could sue the lawyer for what is owed to them.
The outstanding on the loan.
Yes.
Yeah, but
So
this,
That's
the
why the buyer now has to sue the lawyer for what they have paid.
for what they've already paid,
Yes,
so that they can cover their losses.
their losses.
Okay.
so that means once they find out that it's fraud, that means what? That the buyer stops paying?
How can you stop paying? You have a contract.
Correct.
And then
So,
The bank has already paid all this money to you.
so now that's what I'm saying. So the buyer is the person who is in, okay, so they're suing the lawyer and they find the person, they sue the lawyer and the person. The two of them ain't got nothing. So now the person who bought the fraudulent property is still paying. So they are obligated to pay the bank back. The bank is suing those persons, you're suing those persons. What is the bank suing for if they're getting their money?
They actually had to spend money to do the title search, came back
Mm-hmm.
non-fraudulent.
So the bank does a title search, their lawyers do a title search, and your lawyer do a title search, correct?
No, the bank
No.
pays the lawyer to do the title search.
No, that's a part of your mortgage.
What you mean?
Okay, so when you're purchasing a property, who pays for the, isn't that the legal fees that you pay?
The title search?
Yeah.
Yeah, but don't forget now, before you get the mortgage, when you enter into an agreement of sale to buy that property, your lawyer, the buyer's lawyer, and the seller's lawyer,
Are two different people.
they go through the process to ensure that there is good title.
Right. Two different
Correct.
types of people.
That is separate from when you go for the mortgage.
Okay, so now when you go for the mortgage, the bank's lawyers do their search.
Yes.
Okay, so here goes now. The bank's lawyers do their search. The client's lawyer do their search. Both agree that this property is good to go.
Mm-hmm.
So the bank lawyers also is at fault.
Yes.
Yes.
So the bank and the purchaser suing both lawyers and the seller.
Yeah, they're gonna have to do it like that
Okay.
and let the judge decide as to who, at the end of the day, they will remove from the matter.
Okay. That's the underlying question.
Right. The judge will
Because-
then decide who to take away from this matter.
Gotcha.
It's better to do it that way than to leave someone off and try to add them on. You put them all there and let the judge say, no. This person is not a party to this matter because of whatever. Everything boils down at the beginning, before when the judge gets it, based on the affidavit that is prepared. Because the first thing the judge is going to look at is whether or not any of these lawyers were in cahoots with the seller. You understand what I
Okay.
mean?
Yes, ma'am. So keep in mind that the banks now have a stringent list of lawyers that customers are allowed to use.
Agreed.
So in essence, you are not actually choosing your own lawyer. You are painted in a box and they're giving you, okay, these are the 10 lawyers that our company put faith in. So you have to pay, and you're really working with their lawyer, even though the bank lawyer says Graham Thompson and Co. And then the other 10 in the box is the ones who they cherry pick to say the bank is going to do
Right.
business
So
with them.
that's why I'm saying now, the borrower then decides that I am not only going to sue the bank because I want to stop paying this, but I also going to sue the lawyer for the funds that I have already paid.
Gotcha.
Right. You see, then the judge will decide after he reads the affidavit of the borrower, the affidavit of the lawyer that the banks assign, and the affidavit of the bank, he then decides who he is going to hear the matter from. In the meantime, the borrower who entered into that sales agreement needs to bring a lawsuit against the seller, maybe even against his own attorney, because his attorney, as a part of the agreement for sale for the property, supposed to request from the seller's attorney a good root title. And if he doesn't get a good root title, he should not have agreed to tell you to purchase the property. So that's negligence on both sides. And if you can prove, and if you could actually prove fraud, that makes it even worse. It gets complicated.
Yes, ma'am.
It gets complicated. All right, so for tonight, like I said, I didn't want to confuse you all for the exam. So what I wanted to do was chapter 7, which is customer due diligence with regard to money laundering, which I know you all know very well. And on the final exam, there will be a question on money laundering or a scenario or multiple choice, one of the two on money laundering. So what are the 3 stages of money laundering?
Placement, layering,
layering,
and
and integration.
integration.
Okay,
Integration.
right. So when we speak about money laundering, the law itself has now defined what they call risk offenses. So this means that what the Bahamas has done is they have identified risk elements that they foresee will actually drive money laundering in the Bahamas. So what are those risk offenses that are being identified?
That's like terrorist financing, in fact.
Yes, that's one. Let's go. You all do this every year, so you
So
should know
like
this.
human trafficking.
That's 2. What else?
Drugs.
Cybercrime.
Cybercrime, yes.
Any type of corruption, I guess.
Corruption, yes. Not drugs, money laundering. Money laundering is an identified risk.
So that's when you move, like you have to declare declaration, like if you're leaving the country, you only can take so much money out or travel with so much money.
Yes, you're talking about the travelers regulation.
Oh, so that's a different regulation.
That's a different, yes, it's a different one. The proceeds, remember now, when you talk about the AML framework in the Bahamas, remember in the very first class when we looked at laws, and I told you, for money laundering, it governs all of the business in the Bahamas. Doesn't matter whether you're a bank, a trust, money service business, if you're doing money transfer business, if you're selling cars, all of it is governed under the Proceeds of Crime Act. All of it. Every company has to ensure that they follow the law under the Proceeds of Crime Act. If you have clients and you're keeping documentation, then of course, you have to follow the KYC requirements for your clients. So you have the Financial Transaction Act and the Financial Transaction Reporting Regulation. You have the Financial Intelligence Unit Act and its regulation. You have the Anti-Terrorism Act. So all of these things govern money laundering and terrorist financing in the Bahamas. And the act says that it makes it a crime if you conceal the offense, if you make an arrangement with the proceeds of crime, if you use or possess the proceeds of crime, all of those are crimes in the Bahamas. So that means that if someone is selling drugs and they come home to you and they give you some of those monies, and then you turn around and you spend it, you will also be arrested.
Even
because
if you were unaware?
Now, hold on now. You use that word unaware. The law says that if you know or you suspect,
I have reason to know,
or you ought to reasonably have known.
Yeah.
So the law now puts it on you to prove that you had no knowledge at all.
So ignorance is no defense in the eyes of the law then?
No. So you would have seen over the last 2 years after this act came into being, because it came into being in 2018, you would see where the court brings before them not just the person who did the crime, but also the person who participated in the proceeds of the crime.
Does money laundering here in the Bahamas speak to taxes,
Yes,
tax evasion, or?
yes, that is also a crime.
Okay.
Failure to disclose that you suspect that money laundering is going on is a crime. Even the auditors who audit the books, if they fail to disclose, that is a crime. If the MLRO has before them a matter and they're supposed to make a decision whether or not to report it or not, they don't report it, and it turns out that it should have been reported, that is also a crime, because they're gonna have to justify why it was not reported. How did they come to the conclusion that it was not money laundering or the proceeds of an identified risk? Additionally, it's a crime if you tip off the person who's under investigation. And if you look in the Proceeds of Crime Act, at the very back, there is a new section, and that deals with actually the Attorney General's office asking banks for information on the net worth of clients, and also giving the court the power to seize the assets of persons who have committed offenses under the act. So my next question to you is, who are PEPs?
Politically exposed persons. I mean, that's what
Yes.
that means.
Yeah, and
Yeah.
who are they?
So I'm guessing like politicians. A politician is a PAP.
Uh-huh.
Or even
Um,
persons related to politicians
yeah.
that work in the industry.
Family
Spouses,
members.
judges, commissioner of police.
Mm-hmm. Who else?
Senior government officials like permanent secretaries.
Mm-hmm. And
Wow.
even people on the family islands, even family island administrators can also be PEPs if they are actually giving a budget to administer. Remember now, anytime you talk about an identified risk and whether corruption is involved or money laundering or terrorism, is whether that person has affluence, one, and two, whether they control monies or they issue contracts. That makes them PEP.
Right.
So the law says under the FTRA is that you have to have KYC on your clients. You have to carry out due diligence, know who they are. And then once they are a PEP, then you carry out enhanced due diligence. Because what you're really looking for to see who they do business with and why. Because the whole point is that if they are involved in money laundering or any of the identified offenses, they will use persons who are affiliated with them. So the act says that you should try and keep your KYC as updated as possible. So does that mean every time a client comes into the bank, you ask them information?
No.
I mean, the information may change from time to time.
Yeah, it may change from time to time.
So,
And I don't think there's anything wrong with just asking, are you still employed at
right.
such and such a place?
That's what
It doesn't hurt.
Mhm.
Rather than waiting until the information is so stale until it becomes like the Maurice Clinton case, where they asked for a ton of information. He
Mhm.
provided some, he didn't provide some. But as far as he was concerned, he had provided enough information to keep his account open. And that was where the differences became a sore point between him and the bank. Because as far as the bank was concerned was, you did not provide all the documentation that we asked for, so we're gonna close your account.
It's actually
And that's
that
what we
case.
did.
Oh, sorry, that case was the Maurice Clinton.
Maurice Clinton, yes, the
The-
attorney.
Oh, okay. Well, I know he won his case then. Okay.
Of course he did. He won
Okay.
that.
Oh my God.
He won that. He won that case. And so you know that if there is a suspicious transaction, what's the process? If there is a suspicious transaction, what's the process?
Well, if the officer, you're gonna, and it could be the teller feels that a transaction is suspicious. Of course, they would raise an alert, not to the customer, of course, but they would raise an alert to the supervisor, and we do have a process by where we have a form, a scam form that can be submitted. And the scam form is submitted to our head office, and they kind of take it from there, doing the investigation and reporting the matter to the, I guess you could say, PCO, yeah.
But don't forget that.
Compliance.
Right. So you don't normally have to go to that channel. You can actually go straight to the MLRO.
We don't know, you can't learn the branch.
You can? Why not?
Because
Is
we
Because
have,
that-
it's a chain of command.
You don't
Escalation
feel
process.
comfortable. What if the person you're going to report on, you see that person every time they come in the branch, they're having a chat with the branch manager and you suspect something? Do you go through the branch manager?
No,
No, because you can actually go straight to the MLRO.
no, the bank has an officer in branch for that purpose. That officer is tied directly to compliance. So it's not a management team
Chain of
member.
command.
Okay, I understand. I got you now. Okay. I understand now.
Mhm.
Okay, well,
For us, I mean, what she's saying is similar, but with us, we do a UTR, unusual transaction report, and it goes directly to our compliance department. I don't
Yeah.
think it doesn't go to somebody in the branch, but everybody
Yeah.
operates different.
but
Only
yeah,
work
but
for
that's,
Scotia.
No RBC.
yeah. So that's how it works. But normally you should be able to just go to your MLRO and advise if you know of something suspicious. Especially if you notice that people within the branch or the area where you work are very familiar with that person.
Well, I think for us, you want to make sure that your suspicions have some basis, because when we actually do refer to compliance, we get a ton of questions like we're being investigated. So they just want to make sure that before we present a case to the MLRO, that it's actually a case that has some meat to it, as opposed to
Like
some-
what kind of questions? Because don't forget now, the MLRO is supposed to do an independent investigation and come to their own conclusion. And so
Yeah.
if that means that the MLRO now needs to take that file and look at the KYC, which they should be able to see from their own system, they should be able to look at the transactional history and come to a decision as to whether or not they think money laundering is taking place.
Mm.
It's independent.
Well, yes, the compliance considers itself independent from the bank.
Right. So at the end of the day, you should not even know whether or not it went further or not.
Agreed, you don't.
Yeah.
They ask you a number of questions, you answer them, and that's it. You don't have to.
Yeah. Yeah, and that's it. All right. So now, Natonya, are you taking this exam on Wednesday? Yes. Yes, you are. Come on, there are no surprises. Everybody knows what's coming on the exam, correct? Yes.
But how, we didn't know it's coming, but how it's coming, that's the question.
What do you mean, how?
Because
I don't understand,
the way
understand that
you-
word.
the way you deliver it, the way it appears, I'm be honest with you, Ms. Archer, you seem to want an exact kind of answer.
No, no, I don't. I just want something that makes sense. No, I don't want exact. I can, if you put it in your own words, I know whether you know it or not. Doesn't have to be exact. Doesn't have to be. So I have 3 people taking it on Wednesday. Nobody else wants to join. And 5 next week.
Yeah.
Just saying, yes, I hear that. So that's Colette, McQuell, and Natonia will take theirs on Wednesday. And Doris, Denise, Atia, Bernique, and Waltine will take theirs the following week.
Yeah.
Okay.
Sounds good.
Sounds good?
Yes, ma'am.
All right. So on Monday coming, we're going to do the chapter before this one, which is accounts. But don't forget that is not a part of your midterm exam. So don't get confused. That's why I didn't do it today. Because normally people get confused, and then when they write the exam, they start writing on the chapter where we just did and forget the fundamentals of what I'm looking for. Okay?
Yes,
All right.
ma'am.
So happy studying. I hope not to be disappointed when I look at my first set of exams, but I won't mark it until I get the ones from next week.
Okay.
Okay?
So the exam is just paragraph type questions. And
Short
scenarios.
answers, very, very short answers, remember?
Don't sound so.
The first part is just, the first question is only very, very short answers, and then you have scenarios. One of the scenario has 3 questions in it, and I told you those 3 questions are 3 short questions. You shouldn't be writing an epistle. Your epistle should be on the other 3 scenario questions.
And then we have the thing for chapter 3. We have the case.
You have that case, yes.
No definitions or the short answers?
The little short answers are like definitions.
Definitions, okay.
Yeah. But I said you need to give me 2 or 3 sentences. It's very short. Do
Okay.
not write long histories because it's not a long history question.
Okay.
All right?
Ma'am.
Okay. So I'll let Ms. Nee know who's taking it on Wednesday. And then I'll give her the names for next week and let her, I guess, send you all an email as to which day you all can come and take it. What
Okay.
about Tuesday? Tuesday, anyhow, I'll let her decide. I'll let her tell you.
Okay.
Okay?
Okay.
All right.
Thank you.
So you're most welcome.
Thank you.
Okay, you're welcome.
Oh, Lord. Ms. Archer,
Yes.
you sending me some information or someone sending in the group or what?
That
Yeah.
you said you're putting in the chat?
Yeah, but I don't have anybody's numbers.
need
So
numbers.
whoever has all the numbers can create the group.
Oh, the phone numbers. Ooh,
That's important.
that's a point.
That's very important. I guess I could
Yes.
always, if people wanna give me their numbers quickly.
Can we put it in the chat now?
Because, yeah, but I would need your number.
Okay.
Check the chat.
Okay,
And you have my number, right?
I have your number, yes, ma'am.
Okay, all right. So put it all in the chat. Because what I'll do is I'll send the link for Maurice Clinton and Makushla in the chat after you finish sending the rest of the stuff.
That'd be good.
Yeah,
Thank you.
okay. And Denise, everything will be in there. If you're missing it, Denise, if you're missing anything else, let us know.
Thank you.
Okay, so you'll send that the relevance of banking versus contract. And I'll send the Maurice and the Makushla case. But
Okay.
you don't have to worry much about the Makushla one now, but you know the Maurice one, you need that for the midterm exam.
Okay.
Yeah, okay. So once you establish the group, I'll send the link for that. So everybody provide their numbers so she can put it in.
Okay, and then-
Okay, I sent mine.
So there's 1, 2, 3, 4, 5, 6, 7, 8. One, 2, 3, 4, 5, 6.
Including yourself makes it 9 and I make 10.
Okay. Got it.
Good?
Good. Thanks.
All right. So I'll wait until you send all and then I will send my link. Let me look for it.
Okay.
Okay, so I can add that in there.
Okay, good night.
Okay, so good night, everybody.
Good
All right,
night.
good night.
Okay.
Bye.
Good
Take care.
night.